Hi, and welcome to Cam Resource Podcast, Episode 3, 2017 Legal Update. Today we're here with Steve Mezer. Steve and I have worked together for many years. We're not going to say how many years because we don't want people to know how old we are. But Steve, thank you for coming today. Tell us a little bit about you and your firm and where you're located, that kind of thing.
Hi, Di. Well, I've been doing community association law since about 1980-something, and I'm board certified in real estate by the Florida Bar. I'm a past chairman of the Condominium and Plan Development Committee for the Real Property Probate and Trust Law section of the Florida Bar. I am a fellow of the American College of Real Estate Lawyers, and I am a past chair of the Common Interest Housing Committee for the American Bar Association, and presently a shareholder at Becker Poliakoff here in Tampa, and the resident shareholder for the Community Association Law Practice Group for the Tampa Bay area.
Wow. So, Steve, today we're going to be talking about the legal update for 2017, is it?
It is.
And we need to say here, because this could be listened to nationally, the state of Florida.
That's correct.
State of Florida. So, just in case you're listening in another state. So, Steve, we'll just kind of touch on each one of the new revisions and kind of, if you feel something's important about it, kind of go in. If I have a question, I'll just ask you at the time. How's that sound?
That's great.
Okay, great.
Well, the overriding theme for the 2017 legislative session for Florida related to a grand jury report that came out in February from the Miami-Dade County Grand Jury relating to two condominiums that had real serious legitimate problems with their elections. In one, they had 115% of the owners voting. As you know, it's hard to get maybe even 50%, but they got 115%. And people challenged that, and they were correct to do that. And they went to the Department of Business and Professional Regulation, and they could not get any help there. That was not within their jurisdiction. They then went to the state attorney's office in Miami-Dade and complained, and they said, well, we don't see a crime here. So the legislator from that area went to Tallahassee and started to implement criminalization of certain conduct within a condominium so that the state attorney's office could in fact prosecute certain crimes within a condominium. And that was the overriding theme for the 2017 legislative session. We're hearing that it will also follow into the 2018 legislative session as one of the key themes. What they did in House Bill 1237 was amend 718-111 to add 4 instances that they thought were in need of criminal attention. First one relates to receiving things of value or kickbacks by board members in particular, and almost all of these are focused against board members and not unit owners. And if you take a kickback, it says that it may result in criminal penalties as provided in 718-111-1D. Unfortunately, there is no criminal penalty cited in that statute for that conduct, so they may have to come back for that one. The next one was forgery of a ballot envelope or voting certificate, and that would be a forgery. Unfortunately, the forgery statute doesn't mention ballot envelopes and voting certificates as documents that can be forged. It has to be an official instrument, so I think they're going to have a problem with that one. The third one is theft or embezzlement of funds of a condominium association, and they cite to the theft statute. That was always a crime anyway.
Yeah.
So
You would think so.
yeah.
I hope so.
But again, they made their point. And again, the ones from the grand jury report had to do with elections, not theft of funds, fortunately. But at least they've made that clearer. And the last one has to do with the destruction or refusal to allow inspection of the official records in the furtherance of another crime. And they're saying that that would be either tampering with evidence or obstruction of justice. There's a little bit of a problem with those, but at least, again, they've made the point that if, in fact, you deny someone access to the official records in furtherance of a crime, which would typically be an embezzlement situation,
Okay.
where they're covering up their crime, that in fact it would be a second crime for you to do that with the condominium records.
Okay.
In that same context, they put in a provision saying that an officer or director who's charged by information or indictment must be removed from office until the end of that case or to the end of their term. Well, that goes against the idea of innocent until proven guilty, but they're putting the interests of the condominium association ahead of that individual's civil rights and saying, wait a minute, we're going to protect the condominium association from that person who is charged until the charge has been disposed of.
And who actually charges them?
Be a state attorney's office.
The state attorney, okay.
So it's more than just an arrest
Yeah.
and not a finding of guilt yet by a court or by a jury.
So it's kind of important for board members to realize this is not a game. You have to really be serious about your elections and anything to do with the association.
Correct. And while that charge is pending, they say that the person who is charged cannot be appointed as an officer or director, and they do not have access to the official records. That latter one is problematic because, let's face it, most of the official records are electronically maintained, so it's not as if they can tamper with them. And the current rights under 718.111 are to allow access for copying. So why would they not be able to copy records? And it says that they need a court order to do that, which is certainly burdensome and unnecessary, but it makes the point that
So
it is
they would
serious.
have a hard time building their own case
Right.
if they can't get to the records,
Right.
right? I mean, okay, so you think that's where there'll be some trouble in that one?
Yeah, I think so, and it remains to be seen, and yet legislators are already queuing up for 2018 to make it even more clear to board members that your conduct can be criminal and that there will be sanctions and penalties if you violate the statute.
Interesting.
You want to move on to websites?
Yes.
Okay.
We're all interested in the websites because if you don't have one, it looks like you're going to have one, right?
Well, yeah, it's kind of interesting. The statute that came into effect July 1 of 17 requires that if your condominium has, actually your association has 150 units or more, that you need to have a website by July 1 of 2018. And the statute delineates an entire list of things that have to be on that website. The website would have to be password protected and accessible to all the owners. Within that website, you need the typical things that we'd find in the official records, like the declaration, bylaws, articles, and rules. Then they get into the annual budget. Then they say financial reports that will be considered at a meeting. And as you know from your years of being a manager, you don't consider financial reports at meetings. So that one's going to be interesting. The certifications of the directors, which is really a good reminder for directors to get certified. That's within 90 days of election, either taking the class or signing the form saying that they've read and understood the documents. Then they have a section on contracts and transactions in which a director or officer is related so that there may be a potential conflict of interest, and they want those specifically posted. Disclosures of conflict of interest, again, keeping with that theme about the grand jury report that board members are to be held accountable. They have notice of board meetings and agendas for the board meetings, same thing, must be on that website. Items which are not to be accessible to unit owners, such as driver's license numbers, social security numbers, anything relating to ID theft, must be redacted. So the board has an obligation, before you put it on the internet, you should remove the identifiers so that we don't contribute to identity theft. The statute also gives the parameters for the website as it being an independent website or web portal, that the website or web portal can be operated by a third party. But at the end of the whole transaction, the information on that website belongs to the association. So that if a third party company has set up the website for the condominium association, which is the typical scenario, after that contract's over, that third-party provider can't hold the information hostage, saying that's our work product, we put it on there, you don't own your own information.
So Steve, I have a question on, let's say you have a website and you put your governing documents on a section that's not password protected so that realtors can get to that. Is that okay? Would that?
Certainly, they're in the official records of the county, and
Okay.
virtually every county in Florida will allow you, as a member of the public, 24-hour access to recorded documents. So your declaration, articles, and bylaws for a condominium are always there. For an HOA, most of you have your articles and bylaws recorded, and you'd always have your declaration. So those kind of public documents are probably helpful if they're found in a public section on that particular website.
And maybe make sure your attorney has sanctioned the documents to make sure that they're legal and up to date, because what will happen is realtors will get that because they're required to give it to the new homeowner. So it's important that that's a good set of documents that you have up there.
Yes, including all of the amendments. And this is probably one of those situations where more is better than less. Don't just say, hey, these are our current documents. If you have, a series of amendments, put them up as well. The next section, dealing with financial reporting, the owners have a right to the most recent copy of the financial statement, and it's got to be given within 5 business days of the request. The prior statute had an exemption for condominiums with fewer than 50 units and allowed them to do basically a report of cash receipts. Now it's based on their budget, and they have that same standard for the compilation, audit, and review that every other condominium in Florida would have.
And what we're going to do, I guess most of this will be pertaining to 718, which is condominiums, correct?
Yes.
So unless we say something different, just go ahead and assume it's for condominiums.
Yes, the legislature focused on the condominiums. Again, it goes back to that grand jury report. They found that the condominiums were most in need of legislative attention, and I do think that in the 2018 session, it'll be much the same, with the exception of Airbnb. The constituency, particularly in the Orlando area, has gotten quite concerned about the proliferation of Airbnb transactions, particularly in some of the high-end communities. Apparently it was okay when it was in us common folks, but the high-end folks weren't as pleased with that concept. The financial reporting, one last section in there, the association has to file an annual report with the Department of Business and Professional Regulation, giving the names of the financial institutions in which it has an account. Again, it's a reporting item, not sure why, but it allows the owners to find that information out from Tallahassee that they're not able to find out locally. The same bill also has a restriction on debit cards, and that was pretty interesting because it's not applicable to credit cards. I don't know, are you finding debit cards being a problem?
Well, I have used them on a couple of associations, mostly because the whole guarantee of signature situation. So whenever you go to a bank, you can get a debit card without a guarantee of signature. So a lot of the associations were using the debit cards for that reason, because nobody really wanted to sign a credit card because that would put them legally liable for it, even personally. So that's why the debit cards were being used.
Interesting, because I'm finding the complaints that we're seeing have to do with the credit cards, and it's a person, whether it's a manager, board member, employee, going to, we'll use Home Depot as an example, and charging things that don't belong to the property. It may be intentional or unintentional, and then we also have had board members who go out to dinner
and use
on the association's credit card.
They're renting it for everyone.
And they have, and I think that this may be coming next. On the debit card, you cannot use a debit card for association expenses, and again, it's limited to condominiums. If you do use a debit card for an improper purpose, in other words, not an association expense, that would be credit card fraud and punishable as credit card fraud.
Yeah.
Now, I had asked the people involved with the legislation, what were you singling out debit cards over credit cards? And they said because that's direct access to the association's checking account.
It is, yeah.
And if you got the Home Depot charge or, say, a MasterCard or Visa charge, you could at least dispute it and do something with it and not pay it, as opposed to having direct access to the accounts. On the recalls, that was another issue in this particular bill. They removed the stated ability of the board to contest the recall. The board still has to call a meeting within 5 days of the recall, but they don't say what they have to do at that meeting or what they can do as a result of the meeting. The state just recently has proposed rules to implement this statute. There probably will be a glitch bill dealing with this statute because it's just not clear. The state also addressed the arbitration program and opened the door to the state hiring attorneys to be arbitrators, and they give the qualifications. In here, they also have a provision that says the arbitrator shall conduct a hearing within 30 days after being assigned. Prior to the bill coming into law, I was noticing that the arbitrators were calling these status hearings. Let's find out what's going on, let's discuss it.
Yeah, I've been to a couple of those.
Right? And they're very helpful, and they do help move the case along. But the arbitrators have been reading this now to say they have to conclude the case within 30 days. And whether that was the intent or not, it certainly helped that situation dramatically. The bill also indicates that the arbitrator must issue their final hearing within 30 days, their final decision within 30 days of the hearing. So again, you get that report. I had one in 2016. The hearing was held in February, and the final order didn't come out till like November. And the client was understandably upset with the state and myself for not being able to control the state.
Right.
But now with this, I think everybody will be quite pleased that the written decision has to be out within 30 days.
Moves it along.
It does, yes. One way or the other, it will help. Another bill that was in the 2017 session was House Bill 6027, and it removed the 3-year cap on waiving the audits. So condominiums previously could only waive an audit for 3 consecutive years. That's gone. They can waive it every year from now on. So I think that one will be helpful.
Save $2 to $5 grand a year.
Easily. And if you're a well-run, well-managed association, that $2 to $5 grand for the audit was probably an unnecessary expense. Let's go to estoppel certificates.
Now this one's for 720, right?
It's everybody.
Everybody,
This
including.
would be condos, cooperatives, and HOAs, homeowner associations. And they basically rewrote the rules on estoppels. In fact, they redefined estoppels. If you, prior to this being law, had asked most people what's an estoppel, they would say the ledger. Now, I don't want you to tell on your manager friends, but are ledgers ever accurate?
Well, we hope they are. Let me say that.
Yeah, everybody hopes. Come on.
Well, there's a good chance that things are going on when a management company or accountant receives those forms. There's a lot of stuff that may be going on that may not show up.
They also don't post things like interest and late fees every day.
Right, daily. Right.
And some of them post things just really for record-keeping purposes. It might be a damage charge or a duplicate key charge or some other kind of fee that is entirely proper within that particular property, but it doesn't belong on the ledger.
Okay. What about a fine?
It may, if the documents say the fine is to be treated as an assessment, it can go on the ledger.
Okay.
But again, there's that variation. So they've created this whole new definition of what an estoppel is, and it's long. And they've got a state recommended form. And for the most part, it's okay. You've got the date of issuance, the name of the owner, the unit designation and address. Then they say the parking or garage space number, which is kind of interesting because they're not always numbered. Some have letters and some have other designations on them, but that's what it says. Then they have the attorney's name and contact information if a delinquent account's been turned over to the attorney, and say that no fee may be charged for this information. So some people have been filling out some of the form and stopping with that particular entry and then doing no charge. That's not really what this is all about, but that's the way they're interpreting it. The fee for the estoppel must be stated, the name of the person who was requesting it. the periodic assessments, when the next one is due, the amount of the next installment, itemized list of special assessments and other monies owed. And then there's a section for what they call other information, and they can talk about capital contributions, transfer fees, approval fees. Then there's a line that says, is there an open violation of a rule or regulation noticed to the owner in the association's official records? Well, most of the violations are not just the rules and regulations, they're the declarations. That's not part of an estoppel according to the statute. Then it gets worse. They ask, do the rules and regulations of the association applicable to this unit require approval of the board of directors for the transfer? Now let's take that apart. Do the rules and regulations, not likely, right?
Right.
Of the association, which is the corporation.
Right.
So they missed the target twice.
So it doesn't require, but we could put it if we wanted to, right?
Absolutely.
Okay.
Yeah.
Okay.
Common sense should apply.
So, okay. All right, great. Yeah, okay, good.
Contact information for other associations. You're familiar, there's a property here in Hillsborough County that has 7 different communities that can lien a property. So if you own in that community, you have 7 obligations to pay. It's a retirement community, and they have lots of different functions that apply. So you would have to supply that information. Some places have like a rec association, a master association, or their sub-association, and it's helpful. Association may at its option include additional information on the estoppel certificate. The certificate has to have a shelf life, in other words, a good until date of at least 30 days if they're providing it electronically or by hand delivery, 35 days by mail. Some of my peers were making them very short because they were afraid of liability. Say, well, I just don't know what's going to happen more than 10 days from now, so I'll give you a certificate that's only good for 10 days. Well, if the closing was on the 11th day, they had to buy another one, and
So it was upsetting everyone. Yeah.
upsetting, expensive.
Creating a lot of more work for everybody also because you had to refill out the form.
Yeah.
Okay.
And confusing. The association is allowed to supplement a certificate. This was originally intended to correct errors. People make mistakes, they see the estoppel certificate, and they say, oh, we left out something, we didn't calculate something correctly, we made a math error. But now we also are looking at concerns over violations. When we issued it on Friday, we didn't see a violation. Monday we came in and we found out there was a violation. So we need to supplement the estoppel certificate so the buyer doesn't get a surprise. Welcome to the community now.
Now you have to clean your roof for $500.
Exactly. Yes, welcome to the community.
Yes.
If the provider does not get the estoppel certificate in a timely manner, they cannot collect their fee. They tried originally to say they can't collect the assessments, but that really wasn't going to work, so they said no
assessment
fee.
had to be paid, but yeah.
Yeah.
Well,
The maximum fees, $250 if there's no delinquency. And that one's kind of interesting. I've heard both sides of it. Many people saying they've now raised their fee to $250. A few people have said begrudgingly they had to lower it. And there's $100 for a rush estoppel, which is within 3 days of the date for production. That one's somewhat troubling. First of all, I think if you read it, it probably means that it's voluntary on the part of the recipient. If I get it and I'm not able to respond within the 3 days, I'm not forced to respond within the 3 days. And it could get a little uglier. Today's a Friday. What if the closing were today? Could I get a request for an estoppel? It's less than 3 days. No, here's an extra $100. Now you have to do it. That's really not what the statute says. And we don't want the requesting parties to put the associations or their management companies or their board members in that bad position of having to respond literally the same day and only get $100 more for it. And let's face it, we all have other things in our lives. Managers have other properties, board members have lives, and so forth. So that really, it's a good idea, but it may not be practical. If there are delinquencies, you can add up to an additional $150. So that's usually for an accounting fee or getting information from the law firm. The statute also addresses the multiple parcels. We don't typically have too many of those, but it does put caps on the maximum fee for people who are buying bulk units, so they don't have to pay that same $250 fee for literally hundreds of units. That fee, the $250, can't be waived. The right to get it on cancellation of the transaction cannot be waived. So you cannot make it a non-refundable fee. We're starting to see people play games with this statute by adding fees. Oh, you want an insurance certificate? That'll be X number of dollars. You want a 1099? That'll be X number of dollars. And so they're trying to place additional charges on the estoppel information. And candidly, it is possible to do that as long as it's outside of the statute itself. The statute says the fees will be adjusted every 5 years for cost of living. We're looking at a glitch bill to fix that, to say that the maximum fees will be adjusted, not just the fees on that. Want to keep going?
Yeah,
Okay.
let's just keep going.
Got more.
You're doing such a great job. We want to keep
thanks.
going.
Senate Bill 1520 dealt with terminations. That has been a very sore subject for many people who basically condominiums, and they got terminated out of their homes. They bought their home whenever, and now they're being told that they will lose title to their home because a bulk buyer or other person has come in and has decided to terminate the condominium and probably turn it into rental property. And originally, prior to July 1 of 2017, if you bought from the original developer and it was your homestead, you're current in your mortgage, current in your assessments, they had to pay you what you paid. So you couldn't lose money. That was a pretty good consumer protection. The July 1, 2017 amendment said if it's your homestead and you are also current in your mortgage, current in your assessments, you at least get what you paid for it. You don't have to have purchased from the original developer anymore.
That's good. Yeah.
Yeah, it's good. And what had happened, typically in South Florida, we were finding people playing the game of, if I want to leverage, harass, interfere with, whatever my motivation is, the group that is trying to terminate a condominium, I'd buy the last few up at a ridiculously high price and make them pay me back my money plus whatever else I could get for it, and try to hold it up. So they're trying to say, look, we don't want that to happen, but at the same time, if it's their homestead,
Right.
and they just found themselves in that unfortunate situation where they paid a lot of money for their home, and now the assessed value is less, particularly because a bulk buyer has come in. There's no ability to get financing. There's nobody who wants to buy into that condominium anymore. And the comparable transactions, because they were done by the bulk buyer, are a lot lower than you paid for yours. They're saying, no. If it's your homestead, we will protect you. And I think that's a pretty good deal.
The word homestead is the secret there.
Yeah, it is. It is. And that's how they'll distinguish between them and that other person who's a speculator trying to do bad things. Previously, if 10% of the owners objected to termination, it could block the termination. They reduced it to 5%, meaning it's easier to block it. The prior statute had an 18-month period where if the 10% had voted against it, you couldn't come back for 18 months. Now with the 5%, it's 2 years. Again, making it just that much harder for somebody to terminate a condominium against the interests of the existing owners. And again, all you need is 5% to block it. They also require now the termination plan has to be approved by the Department of Business and Professional Regulation. So all they're doing is really looking that they've checked the boxes. They've complied with the statute. There's been no lapse in their compliance with the statute. They're not saying it's good or bad. They're not saying that it's fair or reasonable or good. They're just looking for statutory compliance, a good consumer protection. The state allocated money for that, and they've hired one person up there to handle those applications.
And this is for condominiums only,
Condominiums only.
not
That's correct.
timeshares or anything else? Okay.
Nope.
Just condominiums on that one.
That's correct. I think that's pretty much the 2017 legislation with a little bit of insight to 2018. Anything else you want to cover?
No, I guess maybe we can summarize. I think you need to start working on a good website if you don't have one. Make sure, you get all the items listed on there. We'll actually put these updates on the website in
Good.
case they want to.
It's an interesting point. One more thing I forgot.
Okay.
On the estoppels, it says on the association's website, you have to have the address where to submit an estoppel request. Let's face it, not every association has a website.
Not yet, right?
Right. And so they kind of jumped the gun.
Yeah.
And even the one for the condominiums is 150 units or more. And this one is for everybody. Condos and HOAs, co-ops. You have to have the address of where to request an estoppel. I'm going to insert the word if you have a website, because it just says on your website,
Yeah.
So that's coming. But I think it is a
But that law already went into effect.
It is.
But I guess if you don't have a website, then you wouldn't be going against the law. But yeah, you probably need to go ahead and get the website going.
Right.
Probably, And I think maybe once you get it going, do you think maybe you should have your attorney take a look at it, make sure you're compliant with it?
Absolutely. The other thing about the website, many of the components that are in the statute, it doesn't say how long you have to keep them there. For example, financial reports, minutes. It does not equate to the same thing as in the official records statutes. So I think they're going to need to address that. We really don't care about the bids from 6, 7, 10 years ago. In most instances, at least not enough to put them on the website. It'll get cluttered and confusing.
Okay, all right. So, and then on the estoppels, definitely make sure if you're doing them in-house, make sure your attorney looks at your estoppel. Make sure that, make sure you're compliant with that, because that's where I really see some concerns.
Right, and we're also seeing lenders in particular coming up with their own forms because they want additional information that's not required by state statute. And that's entirely up to the association whether you want to comply.
Can you charge for those?
Absolutely.
Okay, great.
And it's not a limited fee. So if it's going to take you a number of hours to comply, a lot of them ask things like, how many units are rented?
Right, and those are usually in the questionnaires. Was there anything, the estoppel's different than a questionnaire, is that correct?
Yes, it is
And you
different.
can still charge for the questionnaire.
Correct.
I remember the day when the questionnaires were like a couple questions.
Right.
And then they became front and back of one page, and then 6 pages front and back. So that's why the fees were implemented, because they were actually taking that much time. And then that rental question got you in trouble.
Right.
I mean, because a lot of managers, well, we're probably around, 15%. And then a couple of the associations got put on the spot and they weren't at 15%. So they became more liable for that questionnaire. So that's why the fees got up there, because then you add liability to it.
Right.
So,
And the lenders will often factor that into the rates charged for the loans. It's also an insurance factor, so you have to be accurate in that information, which does take time to produce. So there may be instances where the association or manager says, no, I really don't want to provide that information because of the potential liability. Yes, you can put that good faith disclosure on each of those, and I would recommend that you do, saying this is done under good faith, the best of my ability, because 718.111 says you're not going to have liability. I'm not sure if that's really going to apply to other forms of disclosures, but it certainly can't hurt.
well, great. Thank you, Steve. What a wonderful job you did in
thanks.
updating us. Now we're all scared.
Don't be scared. It's interesting. We had a discussion amongst some attorneys, and one gentleman who is a board member in a condominium who doesn't practice this area of the law. And he said, I'm not concerned about this at all because I don't do these things. I don't steal money. I don't
Right.
forge ballots and voting certificates. So this is for somebody else.
Yeah, and I think where managers are more concerned with is the actual website, making sure that and I think because that information's on the website, my thought was, can management companies or associations still, I mean, they won't be able to charge for those documents anymore because they're electronic and people can just go there and get them, which is a lot easier. I think it's great. But like I said, I would just want to make sure everybody makes sure that those documents that are on the website are correct and they're up to date with all the amendments and everything on there. So that's very important for you to do. So, well, Steve, I hope you come back and talk to us about some other subjects.
I'd love to do it.
And we'll put Steve's information on the website, so if you need to contact him directly, you can. Thank you for listening, and have a good day.
Thanks, Ty.
This concludes episode 3. We hope you found it helpful and informative. As always, you can join us at camresource.info for more episodes, or go to our YouTube channel, Cam Resource. See you there.
On the next episode, we'll be discussing computers and common IT concerns.